All right, Annie.
Yes, sir. Good
You would
morning.
just admit people as they come in. I'm going to go ahead and get started. It's 11 o'clock. This is scheduled for a 1-hour CLE. So let's go ahead and get started. Couple housekeeping measures. First off, if you want credit for this CLE, I need you to put your name and bar number in the chat function. Annie is going to take down everybody's name and bar number, and then we'll get that all submitted to the Bar Association within the next 24 to 48 hours. Secondly, you will find in the chat function the slideshow that you're going to see here today. You can download it for your records. I will be putting it on the screen, the PowerPoint presentation, so there's no need for you to open it up to try to follow along. You'll be able to see everything here shortly. Finally, if you have any questions regarding any topic that was discussed here today, I'm asking that you put your question in the chat function. Annie's going to take it down, and at the very end of the presentation, when we have time for questions, I will try to answer most everyone's questions they may have today. Let's go ahead and get started. I'm going to go ahead and share my screen. All right, everybody should see a document titled Probate Practicing in County Court of Law number 1. Now, this presentation it's twofold. It's designed twofold. One, it's if you want to be an ad litem in my court, you have to go through this presentation, this CLE. But secondly, there are some very helpful nuggets of information contained within this presentation that's great for practicing lawyers in County Court of Law number 1, or for any court for that matter. So let's go ahead and get started. Today we're going to discuss scheduling a hearing for County Court of Law number 1, predicting the future and what it may hold and what probate may look like moving forward. Independent, dependent administrations, heirships, and muniments of title, guardianship proceedings, and requirements for ad litems. So a probate hearing, you want to prove it up? How do you schedule it? What do you do? Well, let's talk about that. First off, if you have a uncontested matter, you just need to prove up a will. They're going to be heard on Mondays and Wednesdays, 9 a.m. Now, there's a rotating schedule. Because of COVID, we have changed a lot of the scheduling for the courts. We have tried to change our jury trials and coordinate with all the courts. So I can't tell you which day of the week it's going to be and which day of the week Annie's going to give you, but it's either Monday or Wednesday at 9 a.m. Oh, I'm going backwards. Sorry about that. Contested matters are heard on designated Mondays and Wednesdays. Let me say this, though. If your contested matter is going to last more than 2 hours, you're going to have to get with Annie, and she's going to find another date somewhere on our calendar. It could be a Tuesday. It could be a Friday. I can't tell you which day of the week it's going to be. We're just going to fit you in somewhere. But you need to provide Annie an estimated time for that contested hearing. If it's a simple contested matter, you just have a simple motion, maybe it's a discovery issue, whatever it may be, we can typically hear them on Mondays and Wednesdays. Now, jury trials. This is where things have changed quite a bit. When COVID hit, the courts, I should say, came together and came up with an entire new schedule for jury trials. Fort Bend County is now trying jury trials 4 days a week. Although we haven't had a single jury trial in a year because of COVID, once we get up and running, which I anticipate will be soon, you will have jury trials every day of the week practically. Mine right now are going to be heard on Tuesdays and Thursdays at 8:30 a.m. Now on that date, that's when we begin. We begin at 8:30 a.m. We are picking a jury at 8:30, and it's going to be picked down in the jury assembly room once it's fixed from the flooding. Now you will have 2 pretrial dockets associated with that jury trial. Your first pretrial docket, which is about 2 weeks out, is a general docket call. I'm just trying to figure out which cases are going to trial and which cases have settled. Your second pretrial docket, which will be about 7 days out from the jury trial, is where we will hear all motions associated with that case. This system was devised under the recommendation of the Office of Court of Administration and their guidelines they put out early last year when COVID hit. It may change. It may not. Right now, this is what we have, and this is pretty much a guaranteed schedule through July at this point in time. If your case is set for trial, a docket control order will be entered by the court. Mediation will be set. Let's move on. Now, don't call the court unless you have all of this in order. So, prior to scheduling a hearing for decedent's estates, you need to file the original will with the clerk's office. Don't mail the court the original will. Don't call up 4 or 5 days before a hearing and say, what do I do with this will? Oh, by the way, I've got this in my possession. What should I do with it to get it to y'all? You need to file it with the clerk's office prior to scheduling a hearing. On guardianships, the applicant's attorney, and this has been going on for several years now, so most of you should know this, but you must e-file a copy of your ad litem certification along with the application. And all criminal background checks must be completed through the JBCC. These need to be completed prior to scheduling the hearing. Now, something new that I started about maybe 3 or 4 months ago, and we're still trying to work out the kinks, but an ad litem deposit is to be paid into the registry of the court. It's $525. You will find my standing administrative order, that blue font with the underline. It's a link. It'll take you directly to the order itself, and you can find it on the court's website. Now, once all of that is filed, it's time to call Annie. When you call her, or email her for that matter, she's going to give you 2 dates, and she's going to give them to you via email. She's not going to give them to you over the phone, or if she does, she's going to email you immediately thereafter and provide you those 2 dates. Don't assume that you just get to pick from those 2 dates and those are your dates for sure. You need to pick one of those 2 dates and respond to Annie with an email saying, I would like whatever it may be, March 25th. She will respond to you confirming that date, saying, I have you on the docket for March 25th. If you have not received a confirmation email from Annie, something has gone wrong. Maybe the email didn't go through to Annie. Some wires got crossed somewhere. You need to follow up with her. Now, if an ad litem is involved in the matter, you got to keep this in mind. You have got to work with your ad litem on the date. You cannot just pick a date and then call the ad litem and say, oh, by the way, we're scheduled 10 days out from now. I need you to be there. Ad litems have their own calendars and schedules. They have hearings on other matters beyond that particular case. What I need you to do is work with them. Typically, when we give you 2 dates, one of those 2 dates will work for all of y'all. So please reach out to them. Now, the hearing is scheduled. What do you do next? Well, most importantly, is you file 7 days before your hearing all proposed orders or judgments. I want to provide everybody notice of this, though. If you fail to do so, there is a good chance this court will postpone or cancel your hearing. The reason for that is because Annie reviews every single order or judgment. She makes sure it's correct. She makes sure it follows the statutes. She goes over with a fine-tooth comb every single one. And there's a good chance that she will be reaching out to you and asking you to change maybe 1 or 2 things in the order. Not all the time. there's a pretty good chance there might be a change. Additionally, the final order that you are submitting must be signed off on by all attorneys with regards to the matter. So if you've got a heirship proceeding, make sure the ad litem signs off on it. I also recommend that you email Annie a courtesy copy of that order once you've e-filed it. It just makes things go so much easier. The clerk's office doesn't always notify Annie when something's been filed, which makes it difficult. So a courtesy copy, she gets right on it and she can take care of it immediately. Additionally, you need to e-file all ancillary documents 7 days prior to the scheduled hearing date. This means such things as an ad litem report, death certificate, registration with the JBCC, a certificate of training with the JBCC, all of those ancillary documents that go along with your particular case. And please confirm, this should have been done before you scheduled the hearing, but please confirm that the criminal background check has been processed. Also, any individual who is appointed to a fiduciary role in a proceeding needs to fill out a personal representative general information sheet. That document is not e-filed. It is to be submitted directly to Annie. And for those of you, and I failed to even introduce Annie at the beginning of this presentation. For those of you who maybe do not know Annie Ayala, she is my probate auditor for County Court of Law number 1. Annie, why don't you say hi real quick?
Hello, guys. Thank you for joining us today.
If you have any questions whatsoever, I suggest you reach out to her. She is happy to help in any way possible. All right, miscellaneous items. I'm going to read this one word for word because it's very important. The court's policy on the use of interpreters. If a client or a witness cannot communicate in the English language during a hearing, whether due to a hearing impairment or inability to speak or comprehend the English language, or you need to have a document to be translated into a foreign language, the attorney should complete the interpreting services request form or the translation services request form. Links are provided right there, and submit the forms to Annie Ayala at least 10 days prior to a hearing. The court will pay for all interpreting, and translation, this should be interpretation and translation services associated with the matter set before the court. The interpreter that will be assigned will be master license certified. I know that probably doesn't mean a lot to anybody here, but you have to understand there are certain rules that have been established by the state of Texas and the federal government that require a master licensed interpreter. We will locate that interpreter for you. We will pay for that interpreter. The only thing I ask of you is to submit one of those two forms on what you need. It's pretty easy and simple. Should be painless for y'all. It's just a form, fill it out. We take care of everything else from there. Codicils, make sure you reference the codicil in the title of your document. The reason for that is because posting. The clerk's office typically does not look to the body of the document. They're looking at the title. And if you don't reference the codicil in the title of your document, it's not going to get posted and we're going to have issues. So make sure you reference it in your title. It's simple as that. You got to remember the clerks downstairs are not attorneys. And when they start reading some of these documents, I would imagine some of these young men and women down there, they might become cross-eyed reading that document. So just put it in the title, make it easy on them, make it easy on us. And I promise you, you won't have any issues if you do that. Also, if you want to meet with Annie to discuss your matter or anything for that matter, call ahead of time and schedule. Don't just come on in here and say, hey, Annie, I want to meet with you real quick for the next 45 minutes. She's very busy working on all sorts of stuff. I mean, I can just start listing things off, but I'm not going to right now. She has a calendar that she keeps, and she does make time for attorneys to come in and meet with her for 30, 45 minutes, even an hour if necessary. But don't just show up, because you're going to throw off her schedule, and I can't have that. I don't need her falling behind on other stuff. Now, one thing that's been a hot topic around the courthouse lately is, what are we going to do moving forward with these Zoom hearings? I mean, right now we're on Zoom, right? It's convenient. I don't necessarily like it that much for this type of presentation. I'd prefer to see your faces. I prefer to be in my courtroom talking to each and every one of you and easily answering questions that you may have as they come up. But it does have its benefits. So let's talk about what's going to take place with Zoom for Court 1. I can't speak for all the courts. I'll say that right now. But for Court 1, all contested matters will be heard via Zoom from this point forward. I'm going to repeat that. All uncontested matters will be heard via Zoom moving forward. It has its benefits. I've heard from a lot of attorneys that really appreciate Zoom. They like it. It saved them or saved their clients money. I'll give you an example. I actually had a simple prove up where one of the witnesses was in Germany. Now, everybody knows my policy. They've got to come into court. When we are having in-person hearings, I expect them to be there in person, 9 times out of 10. If they had not mentioned it during the hearing, the Zoom hearing, I would have never known that that person was in Germany. Now, it's the middle of the night there, but they are actually online providing testimony in that particular case. It really saved that attorney and that client quite a bit of money. Instead of flying them in to provide testimony or whatever the case may be, it was easy. I can't tell you how many attorneys also have told me they love it because they can do their hearings from anywhere. I had one attorney tell me, I bought a cabin in Colorado and I'm conducting all my hearings while I'm spending the summer up in Colorado. I can do hearings, depositions, mediations, everything via Zoom. They said, please don't ever change or get rid of Zoom. Now, I've also heard the opposite. I've heard some attorneys absolutely hate it. They want to go back to in-person hearings, and we will have in-person hearings. We'll have in-person hearings on contested matters. I've done a couple bench trials via Zoom. It's not a fun experience. I did not enjoy it. We had too many issues. And when you have 5, 6 attorneys present arguing a case, you have 40 exhibits, Zoom is not the place to conduct that hearing. It's too cumbersome. It's impossible. It really is. So contested matters will go in person once, now I got to also put a little caveat there, once everything is set up with the most recent Supreme Court order, which is the 36th emergency order. There are a couple things that we have to do as a court system here in Fort Bend County and put in place before we can have those in-person hearings. And Judge Williams, our administrative judge for the courts, is diligently working on that right now. So at the end of the day, the takeaway is Zoom is not going away. I made this little sentence right here. I created this sentence that said, the last year has transformed the legal practice in many ways, some of which are here to stay. Didn't mean to rhyme that sentence, but it does. It really has transformed the way we conduct business. I am literally on the criminal side of what I deal with. I'm working with IT and the other courts to set up a electronic process for criminal resets. To where essentially they don't need to appear in court anymore unless to plea a case out or have a hearing. Things have changed a lot since COVID hit. And I'm afraid most of it is here to stay. So one thing I ask of you, I beg of you, please review the court's Zoom policy and procedures. I have provided you a link. It'll take you directly to it. If you want to go look for it, it's on the court's website. It's under documents and forms. It really provides you guidance on how I want the Zoom hearing conducted. It answers almost every one of your questions. In addition to that, I even have a video on my website where you can go watch. It's about 20 minutes long, and it walks you through the Zoom process and what's expected of you. Take a few minutes out of your day and go watch the video and review the policy and procedures. One thing I do want to remind everybody, and we've had this come up, is if you fail to follow those policy and procedures, there's a strong possibility your hearing could be canceled or rescheduled. So please go read those. Some issues that we are seeing on a regular basis. First and foremost, screen sharing. So I've always asked from the very get-go that attorneys share the will when they're proving it up on the screen. Some attorneys have picked the will up and point it in front of their camera and said, well, and to their witness who's, I don't know, 100 miles away. So can you read this? Can you see this? That's really not the proper way to handle it. All you got to do is you save the will to your desktop, open it up. There's a little button at the bottom of the screen window of the Zoom window that says share screen. Click that button, select the document, and pop, it's up on the screen. Just like I'm doing here today, sharing this PowerPoint presentation. It's really not that hard. Now I understand some individuals find this a little more difficult to use than others. I get that, but it's not that hard. It's pretty easy. And I've walked through, again, that video is online where it walks you through some of these processes. Also, failing to properly list your name in the Zoom waiting room. Under my policy and procedures, I ask that you list your full name. And I'm looking at the side of my screen right here, and I can see several of y'all. And I see Shelly Hudson, I see Lisa Pierce, and I see Bustle. I'm gonna call you out, Jerry, on this. He just lists his last name, which isn't that bad because I know who he is. I know, but there's not that many Bustles that practice law and probate out here, so I can easily figure that one out. But when it's ABC 123 or Galaxy 6 notebook, I don't know who you are. And a lot of times what's going to happen is I'm going to save you to the very end. Most of you know by now who've had probate hearings in my court, Miss Ayala, Annie is going to give you an exact time of when your case is going to be heard. It'll be heard at 9:10, 9:20, 9:30. She's going to tell you exactly when it's going to be heard. And we try to stick to that schedule. I move through my probate hearings pretty quickly in order to keep to that schedule. Sometimes I fall behind and I apologize for that, but I do my best. But when you don't have your name listed there, I don't know who you are. And that goes for your witnesses as well. I don't know who you are. I'm asking in my policy and procedures that you list your name so I can easily pull you into the meeting. So what I'm doing at this point and moving forward, you stay there until the end. And it's a process of elimination. Once I've got all the other cases figured out and everybody's names, then we'll just bring you in and say, well, what case, who are you, and what case are you here on? The admittance of exhibits. Again, my policy and procedures covers this. I'm asking that you get those to my court reporter 3 to 4 days prior to the hearing. Typically, if you can get them to a Friday before the hearing, that works out just fine because she's got to have copies of those exhibits. She typically gets me those exhibits as well, and I have them available to me during the hearing. Another issue that I see a lot of is connectivity issues. Sometimes this is completely out of your hands and you have no control over this whatsoever. AT&T, Xfinity is working on the lines and there's nothing you can do about that. But I'm going to make one recommendation. If you are working from home a lot, try to get the highest speed you possibly can with your internet service. If you've got 50 megabytes, that's not enough. You need to be looking at you need to be looking at 50 gigabytes at least to conduct these hearings. I had one the other day where the attorney would get about 2 sentences in, and then she would freeze for about 30 seconds. And then she'd come back, she'd get 2 sentences in, and because she had to pick up right where she left off, because she didn't realize she froze. She kept talking. So we had my court reporter would say, well, you ended on this word with this sentence. And so she'd pick up, she'd get 2 more sentences in, and she'd freeze again. I don't know if it was something with regards to the Xfinity working on the lines or anything like that. But I would, if you're going to work from home, go check your provider. See what kind of service you have. You can get insane speed nowadays with Xfinity, with AT&T Fiber. It's amazing what they provide to you nowadays. I mean, there's a cost associated with it. But I would try to get as much as big of a service, or let me say, as fast of a service as possible to help with these hearings. Final issue, and this isn't that bad, but it comes up now and then, is just properly training your clients on Zoom. Yeah, my recommendation is maybe sit down with them a couple of days before the hearing and practice. Go over it. If they're not going to be in the office with you, if they're going to be conducting their hearing from their house and you're at your house, just practice it with them. Get on Zoom, do a quick hearing, like it's not necessarily hearing, just a practice session, and just see how it works. See what they know. And if they really need help, maybe at that point in time, you realize they can't do this via Zoom, and you can bring them into your office. I mean, I've seen a lot of that where you have the attorney and client sitting right next to each other with their mask on, and they're conducting the hearing. And I have no problem with that. Once you receive your Zoom link, I recommend testing your hardware and software to ensure functionality with Zoom. Zoom's constantly updating their software. I recommend that you just test it to make sure there's been no changes that makes it to where it doesn't work with your camera or doesn't work with your audio. Sometimes with older equipment, if you've got a computer that's 10 years old, a camera that's 10 years old, they may have updated the software so much it's no longer compatible. Just check. All right, independent, dependent administrations, heirships, and muniments of title. These are just issues we see on a regular basis here in County Court 1 that we're going to talk about. Here we're going to talk about applications more than anything. This is pretty standard across the board, but surprisingly, Annie still runs into this issue. Social Security and driver's license numbers on applications. They got to go on there. Make sure they're there. Obviously, you're not putting the entire number on there. The last 3 digits of the Social Security number, driver's license number is what's required. Exact names and aliases. I do require all pleadings to begin with the exact name as they appear in the will for the decedent and executor, even if the person is now known by another name. So make sure you plead or fill out your application correctly. Alternative executor. This one comes up quite a bit. If anyone other than the first named executor in the will is being appointed, be sure to include the name of the first name executor and why he or she cannot serve. Now, you're also going to do this or do this for all other named executors who will not serve, but who have priority over the executor who will serve. I'll also include this information in the order. Executors, the court will require the executor/applicant to personally appear before the court to prove up the will. I guess in Harris County, I know some of the Harris County probate judges, and I've talked to them on several occasions. I'm not 100% familiar with all their procedures, but it's my understanding that a lot of them are not requiring the applicant to appear or the executor. That's not the case here in Fort Bend. Probating a will that is not self-proved. Now, the court requires all necessary witnesses to be present in court. And when I say in court, that's either in person or via Zoom. Uncontested matters, y'all know now, are Zoom. So when I say in court, that's the Zoom courtroom. probating a copy of a will or codicil or lost will or codicil. Again, reference a copy in the title and body of the application, order, proof, and oath. Physically file a copy of the will or codicil that's being offered for probate with the county, with the county clerk, I should say. This is going to allow the court to evaluate the document itself. And also, I've attached a link for the affidavit waiving citation for probate of a copy of a lost will or codicil, or probate of a lost will or codicil without a copy. These are just standard forms that I have on my website. That link right there will take you directly to it. Dependent administrations. This is real simple. Minor errors. If there's a minor error, the court will require dependent administration. Simple as that. Heirship determinations and dependents. I am going to require an heirship of the decedent to be determined at the time the dependent administrator is appointed, unless this doesn't come up very often, but occasionally I'll allow this. Extraordinary circumstances are brought to the court's attention, and what I do is I'll allow it to the deadline. I'll set a deadline, and we'll have that hearing later on down the road. All right, heirship proceedings. The ad litem should be listened carefully at this point in time, or potential ad litems. Heirs, adult heirs must waive citation, be personally served citation, no private process, or receive citation by certified mail. Return receipts. I want to remind everybody, this has been the policy for this court for 6 years now, 7 years. Return receipts will not be accepted from the attorneys. Minor heirs younger than the age of 12. Citation can be served on the parent, managing conservator, or guardian. Now, if they're between 12 and 17, they must be personally served. Affidavit of service of citation, a sworn affidavit from the applicant or a certificate signed by the applicant's attorney stating that all required citation was served, including names of persons who were served or who waived citation, must be filed 7 days prior to the scheduled hearing. Disinterested witnesses. This has been the policy for the courts for as long as I can remember, even as a practicing attorney. 2 disinterested witnesses to prove up an heirship. Not 1, 2. Judgments. So judgments must comply with intestate distribution laws, even if the applicant is claiming the estate consists of only community property. The judgment must address distribution of separate property, as the court, and I'm going to say this, is not making a finding as to the character of the property. Ad litems shall be addressed in a separate order, prepared, the fees, I should say, will be addressed in a separate order prepared by the ad litem. Do not address this in the judgment itself. Now, you can discharge the ad litem in the judgment, but do not address the fees. Ad litems in heirship proceedings shall file a report 7 days prior to the hearing. Now, I had this question come up, and we're going to address this in guardianships, but I'll just address it now as well. You do not have to file a report in a guardianship proceeding. Annie had this question presented to her yesterday, was it?
This morning, Judge.
This morning. Okay, never mind. This morning, that there was some confusion as to the court's requirement as to reports on guardianships. As far as I can remember, for the last 7 years, I have never required a report in a guardianship. Now, if you want to file one, that's up to you. But I've never required that. Heirships, I do. All right, ad litem duties at the hearing. All individuals, attorneys that want to become an ad litem, ears should be perking up at this point in time. Ask questions. The one phrase I hate to hear is, If I asked you the same questions that were just asked to you by your attorney, would your answers be any different? That's not the appropriate question to ask. You have certain duties, and that involves asking them questions. Now, if we're on the second witness, and you've asked all your questions of the first witness, you can't ask them that one simple question of, you just heard the questions that were asked to you of the first witness. If I asked you those exact same questions that I just asked the first witness, would your answers be any different? That's a perfectly acceptable question. But the first witness, you need to be prepared. Prepared to ask them the questions that the court needs to hear. And again, I'm going to address your fee order. It needs to be a separate document outside of the judgment. And I would prefer that you have it filed prior to the hearing. And there's an itemized bill attached to it as well. Oh, sorry about that. Also, for all idle items, I would recommend that you familiarize yourself with the idle item manual. I've provided you a link. It's on the Tarrant County website. Now, Judge King's has since retired, so it hasn't been updated since, I think, 2017 or around that date. But it's an outstanding reference material for idle items. Muniments of Title. Annie, how often does this come up now? I mean, it's starting to become older and older. What are your thoughts? I mean, obviously we have to have this MERP certificate, but is this popping up a lot?
No, Judge, usually we don't. Usually the answer is no, that they have not applied for Medicaid. I do not require the MERP certificate if the answer is no, they have never applied for Medicaid. That's just, there's no issue, because if they've never applied, then there wouldn't be a claim. I don't see this too often. Everybody's usually doing a really good job about that. But every once in a while, I do see someone that attaches a MERP claim, but they also check they never applied. So I usually expect there to be no claim when there was no application.
It's one of these things.
It's not a really big issue that I see very often.
You know, I've done this presentation for, I don't know, what, 6 years now, 5 years now, I'd say. And 5 years ago, for sure, it came up more and more, but it's less and less of an issue. But you need to be aware of it. Attorney idle items shall be appointed to represent the interest of any heirs whose addresses are unknown in a proceeding to probate a will as a muniment of title after 4 years. Again, this doesn't come up very often, but you need to be aware of it. Affidavit of fulfillment of terms. Now, the affidavit will not be waived unless, and it's usually waived because the applicant is the sole heir under the will, or all beneficiaries joining the application file a waiver or appear in court. Typically, we find it's resolved in one of these two manners. I rarely nowadays require an affidavit because they're a sole heir or they filed waivers or whatever the case may be. Sometimes they appear in court, every one of them. Probating a will more than 4 years after decedent's death. Now, again, reference more than 4 years after death of testator in the title and the body of the application. Again, when it comes to asking y'all to put something in the title, this applies to the clerk's office so they can catch it. All heirs and devisees under the will must be personally served with citation, or an alternative, file an affidavit waiving citation and waiving objection for probate of a will more than 4 years after decedent's death. Guardianship proceedings. Everybody should be aware of this. All applicant attorneys filing a new guardianship proceeding after September 1st, 2015 must e-file a copy of their 4-hour certification along with the application. This has been going on for quite some time. Occasionally, we still have this issue, and we have attorneys who file an application who are not certified. It's just a reminder at this point in time. Make sure you address in the application and order all less restrictive alternatives and supports and services. I want to see that. Going back to the criminal background checks, we talked about this a little bit earlier. Except for attorneys who are applying to serve as guardian, all individuals, every one of them, must undergo a criminal background check through the JBCC. PCME, Physician Certificate of Medical Examination. Make sure you're using the most recent form, and I've provided you a link there as well. It'll take you to the form. We haven't updated it since 2016, but it follows the statute. Now, I will on occasion allow attorneys to use their own form. I've even allowed a letter to suffice as a PCME. I just make sure, and you need to make sure that it complies with the code and checks every single box. Registration and training with the JBCC must be completed as soon as possible, but no later than 10 business days prior to the hearing. Make sure you write that down, that 10 days, because a lot of it's 7 days that we've been talking about. This one's 10. All right, the order itself, if it's a full guardianship, address the rights of the ward to vote, drive, make personal decisions regarding residence. Be prepared to explain to the court the less restrictive alternatives and why they won't work. I always like to hear that. I think that's important and as part of the prove-up process. Again, same as airships, do not include the attorney ad litem fee in the order. This will be addressed by a separate order filed by the ad litem. You can discharge the ad litem, just don't address their fees. And then again, at the end of the document, you need to include notice regarding peace officers displayed in boldface type and capital letters. I think this is pretty standard. If you're using a ProDoc form, it's there already. But occasionally we have an order come through that it does not include that language or it's not boldface typed. I don't know where some of these forms come from, but most of them have it correct. Annual report for guardianships. I provide you a link for our form. Make sure you go over that with your client. I'll address it during the hearing at the end and remind them that they're going to have an annual report to file. And I'll probably say your attorney can help you with that. My recommendation before the hearing, you tell them about it. Maybe you pull the form up and give them a copy of the form. And if they have any questions, you go over those questions with them. Because here's what can happen if they're not filing their annual report. So about 30 days prior to the report being due, we're going to send them an email reminding them about their letters expiring and that they need to get this report in. Now, if they don't get it to us with that reminder, we're going to send out late notices with a due date. And if I'm not going to receive a response, if I don't get a response from that individual, we're going to have a show cause hearing. I've held several of them over the last 2 years, I'd say. Not many. Usually people respond when a court's threatening to call you into a courtroom. But some people just refuse to file the report. So we will have that show cause. And there's a chance that they could be removed as guardian if they fail to file the report or they refuse to file the report. I just threw this in here. This is on temporary guardianships. I feel like it's coming up more and more. Wouldn't you agree, Annie? I feel like more people are applying for temporary guardianships nowadays. I've probably seen more in the last 2 years than I've seen my entire 7 years combined. I mean, it's just, I don't know why, but you have to understand that there has to be a clear and present danger to the ward or ward's estate. And that's a very high bar. There are other ways to deal with these situations outside of a temporary guardianship. It's my belief that the legislator set a high bar on purpose. There has to be some real danger taking place before I'm to grant a temporary guardianship. So keep that in mind. Ad litem tips for guardianships. The role of the ad litem is to advocate for the ward, obviously. The best interest should not be part of your vocabulary. That just shouldn't be something you talk about at the hearing itself. Well, this is in the best interest of the ward, Judge. That doesn't have a place here in a guardianship proceeding. Some of y'all are good about this. Some of you just failed to even bring it up. But if the ward's not there, you need to ask me to waive your client's presence to the ad litems, because the ward is your client. You need to ask the court to wait for me to waive their presence. And if they are there, I'd ask you to introduce them as well. I always enjoyed talking to some of these wards. Sometimes it's the highlight of the day. And then also asking to take judicial notice of the PCME. I'm not going to go through it again, but cross-examination questions, ask questions, look to my heirship requirements. It's pretty much the same. All right, ad litem requirements. That's why you're here. It's because of this order, the standing administrative order for the on Fort Bend County Court of Law No. 1, attorney and guardian ad litem requirements. I've listed out what's required. That link at the top is the order itself. It'll take you directly to my website in that order. You can find, if you want, instead of clicking on the link, you can just go to my website. These are what's going to be required of you to get on my ad litem list. I'm not going to read them out word for word. One thing that I do want you to pay close attention to is if your office address changes, if you move, if you change your phone number, get us that updated information. Because if Annie calls you or emails you or sends you a letter and you fail to respond because you've changed your email address, you changed your phone number, we're going to remove you from the list. And to get back on the list, you have to go through every one of those steps above again. This comes up on occasion. Don't call the court to ask when you're going to get your appointment. So back in, I don't remember what year it was now, might have been 2015, 37.004 of the government code was changed. And it took a lot of the power out of the courts on how to appoint ad litems. It set up a rotating schedule for ad litems. It gave some leeway to set up such as what I've set here for County Court 1 and how I'm going to appoint ad litems. But essentially, it's almost the next person on the list. So I promise you'll get an appointment at some point. We're going in order of the list. You just got to give it time. All right, there's their contact information. Everybody should have that by now. You can go to the website, which there's a link again, if you need that or any other information. I've provided some helpful links in this PowerPoint presentation. There's the Fort Bend County probate forms / information that applies to every court. I've also provided a link to County Court of Law No. 1 probate forms and information. And then again, the ad litem manual, which I provided a link for earlier in the presentation. Let's go to questions. I'm going to go ahead and exit out of this share screen. All right, Annie.
Yes, sir.
Now you've probably been taking down these questions. I see quite a bit in the chat room, so I'm not going to try to scroll through all of that. Why don't you
I'm
just read them to
surprised,
me?
Judge, a lot of the chat is the information regarding the Texas bar number and then just the name for the attorney so that I can get them their credit.
Okay.
I have very few questions, actually. I only have about 3. One of the questions is from William Engelhoff. He says, will we be using Zoom? We're not going to switch over to WebEx. Is that something that we intend to keep doing, Judge? We will
Yes.
stick with Zoom.
Yes. So that's a good question. When COVID hit, the Office of Court Administration got with Zoom and bought licenses for every single judge across the entire state of Texas. I started with Zoom, and I really like the platform. I've used WebEx, and in fact, the county has a license with WebEx, and I know my IT department would prefer that I would use WebEx, but I feel like it has its limitations. Zoom is just, it's much more feature rich. I personally think it's easier to use than WebEx. And beyond that, and there's been one knock on Zoom, but that's all changed with all these updates they provided is, well, Zoom is not as safe as WebEx. That's at the beginning of COVID, I would say that was true. That is no longer the case. Zoom has implemented so many security measures, it's almost impossible to do what was called Zoom bombing. Back in, I think it was like March of last year, that was a hot topic of, well, Zoom bombing. These people are coming into these meetings and they're causing a ruckus or they're doing something inappropriate. There's way too many security measures in place now, and I utilize most of them. That's impossible. So I don't plan on changing. Zoom will be the platform County Court of Law #1 uses. I can't speak for all the courts because everybody's a little bit different, but Court 1 will use Zoom. Next.
Judge, the next question comes from Eric Junker, and he's asking the purpose of the deposit, the ad litem deposit, is that to kind of keep the attorneys, their kind of rein in their fees and keep them reasonable, or what's the purpose of the deposit?
It's twofold, really. First off, I have found that some of my ad litems have not been getting paid, and I think it's important that I take care of my ad litems and that they get payment for their services. Now, obviously, I'd love to see the fees set around that $525, but there are always extenuating circumstances where you're having to do a lot more research than you typically would in a particular case. And so your fees are going to be a little bit higher. We can address those. I don't have a problem with that. I think Mr. Dunham, we had a case with you just the other day that we had to address ad litem fees because the research was extensive. I'm not going to go in the details of the case, but it was extensive and we had to address that. We came up with a solution to kind of rein in those fees on that particular case. And that's what I try to do with all my cases. I don't want the exorbitant ad litem fees. I'd like to see them stay around the $525 range, but I also understand there are circumstances that require it to go higher. Next.
Judge, this question is from Farah Ahmed. She says that she's heard that other courts are not requiring the filing of the death certificates due to health information. Will redaction of the death certificate be allowed and then filing? Are we requiring that it be e-filed?
The county clerk's office assures me that any personal information, health information will be redacted by their office on the death certificate. Please make sure you notify me if you filed the death certificate and they are not redacting it. You need to notify the court and let me know, because I'll get with the clerk's office immediately to ensure that it is redacted appropriately. But they have assured me that their clerks will redact the document. Next.
This question comes from William Engelhoff, and he's asking, what is the court's policy on the witnesses for proving up a handwritten holographic will? Can they use the interested witness as stated in the code?
Yes, they can. That was easy. Next.
So this is a good question that I'm actually really interested to hear the answer of this one. It says, this is from Betsy Grubbs. She says, I've run into a problem with law enforcement not wanting to enforce the guardian's order over the person, specifically claiming the ward didn't have to go to X and law enforcement couldn't make them. Doesn't the order on a guardian of the person take away that right from the ward?
repeat that one more time. We'll make sure I heard that correctly.
So Ms. Grubb says she's running into a problem with law enforcement not wanting to enforce the guardianship order over the person, saying that basically they don't have the ability or they won't enforce a person having to do X. So they're asking
meaning when she says X, meaning to go somewhere or go to a doctor's office.
All she says is specifically claiming the ward didn't have to go to X and law enforcement can't make them.
Okay. Well, the answer to that last part of the question was, I believe you had stated, doesn't the order, doesn't the order on the guardian of the person take away the right of way from the ward? And yes, the answer is yes, it does. Unless we have a very limited guardianship, and full guardianships, it's taking away that right. They don't have a choice of where they go see a doctor, where they're going to live, anything along those lines. The guardian has that authority at that point in time. So that might be something you want to address with the court if that arises.
Okay. This question is from Elizabeth Lockett. It is regarding the deadline for watching the Practicing in Fort Bend County video in the law library. My understanding is that we don't have that available still.
Yeah, there's been a lot of issues with that. I'm waiving that requirement this year, so don't worry about it.
Okay.
The law library, I don't know if they've opened back up, but last time I checked, last time I heard, they were completely closed. So, oh wait, Mr. Briggs,
Hello, can you hear me?
Yes, you can answer this.
Yeah, so we've showed that video a few times in the last couple of weeks, through Zoom, and have had people attend that video. Now, like it is like many of the videos that we have, they haven't been updated in a while, but we have offered that a couple of times in the last few weeks, and we had some attendees. As far as this opening, we're still kind of waiting for word from above, as to when we'll be able to open either wholly or to attorneys only, going forward. So we're kind of waiting. There's been some issues, so they're kind of trying to talk it out between, Commissioner's Court and kind of get word from above of, when we're going to open and under what parameters.
Okay, well, thank you for the update.
But
I wasn't aware of y'all's current situation. I appreciate that. Thank you.
Yep.
I'm still waiving it, even though they can do it via Zoom to become an ad litem in my court. I'm going to waive it for now. It does need to be updated. I agree with you, Mr. Briggs. It's been a while. I know I'm on there, but it was probably 5 years ago when I did that. So we've got a lot of new judges in this county, and we probably need to get with the Bar Association and do a new video here soon. Any other questions, Andy? Because we're closing in on our hour.
Yes, sir. Judge, I have one question from Andy Dunham, and he's asking, does the court have any guidance in an heirship proceeding on how disinterested a witness needs to be? He's asking specifically, would an applicant's sibling, et cetera, be acceptable, or do they need to go out further, removed from the applicant? It seems like some courts are becoming more restrictive on which witnesses are acceptable, but this can be a challenge because sometimes family members knew the decedent the longest and have the best knowledge.
I agree with that. A lot of times family members know the decedent better than anyone, and they may have been a recluse. They may have been a hermit somewhere. They had zero friends. They only had family. And even with family, the family may have only spoken to them once a year. I get that. You've got to, for my court, come to Annie, tell her the situation, and she'll come to me and we'll sit down and talk about it. And I promise you, if it's one of those situations where they're a hermit, they don't have any friends, they were stuck in some cabin in the woods and and just never came out and spoke to their family once a year, and that brother is the only one that knows anything about that person, probably make an exception there. Obviously, I'd prefer there to be a truly disinterested witness, a neighbor, a friend, friend of 30, 40 years. But I make exceptions. Just come to Annie. Next,
Oh,
or
yes,
let's
sir. We have-
last
we have-
question because it's 11:59.
Last question is from Francis Nwora. She says, if she has a death certificate that has already been translated, does she need to have it translated by someone, I guess a translator for the court?
Oh. Well, I have one question for you then. Has or whomever conducted the translation, were they master certified?
That's a good question.
If they were not, then you need to come to the court and we will pay somebody to conduct that translation for you.
Okay.
I want to add on to that though, real quick, Annie, before we end this. You should have come to the court from the get-go. The Texas rules, the Texas law, under the JBC, I believe it's JBCC or OCA, one of those two, where the rules fall under. And then of course, Department of Justice rules require us to provide this service at no charge to you. So if you have a death certificate that's in a foreign language and you need it translated, come to the court. There's no need for you to spend money on the translation service of that document when we are to provide it to you for free. All right, Annie, anything else of importance that you
That
need?
was all the questions, Judge, that we don't have any other questions.
Wow, and it's 12:01, so we need to end this.
Yes, sir.
Thank y'all for attending. I had 125 participants. That's amazing. I would have never believed that many people would show up to hear me speak. So thank y'all.
Thank you,
Y'all have a
Judge.
good day. I'll see y'all around the courthouse or via Zoom.
Thank you.